If you enjoy these videos, don't forget to like and subscribe. Thanks. Now back to the video. Lawyers of Reddit, what's your best most badass I rest my case moment? As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. Too bad those assholes already deprived him of 5 years of enjoying that check. To be fair, the check would have been a lot smaller if they hadn't tried to wait him out. His actual damages were only a few $100,000 max, but the bad faith insurance claim opened the door for a much higher recovery, in excess of the policy limit. So when they saw we had a fighting chance of getting that, they just gave us the entire policy limit to settle. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. I wonder how red his face got. If I was that lady, I'd have made my neck injury worse from throwing my head back in laughter. I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "Fuck you, judge lady, you a stupid cunt. Fuck you all for taking my fucking kids, you fucking cunts." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot and I ended up with an A. Not a case winning moment, but a motion winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried multiple times to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add, it was pretty fun." Oh, that had to be excruciating for everyone, especially the court reporter. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gamboni, hands behind my head, and say, "I'm done with this guy." I had a trial against a guy who was self-representing and he was constantly asking my client about conversations she had with me. First of all, no, I'm not coaching her to lie. And second of all, there's a thing called privilege, which means the things we discuss are not compellable. It was an exhausting trial. Needless to say, he was ordered to pay about $1 million more than he actually owed. He could defend an innocent man all the way to death row. Obligatory, not a lawyer. But I was defending myself against a debt collector for a debt so old I could not even remember for sure that it was mine. Me to the debt collector, "Can you provide the actual contract bearing my signature along with a chain of title to the debt?" Debt collector's lawyer, crickets. I look at the judge. Judge to lawyer, Well, can you? Judge, case dismissed. Note, to prove that a debt collector owns your debt, they must prove how it came to own it. Often, old debts are sold and resold over and over again to a number of subsequent debt buyers. When this happens, the debt collector must prove each and every assignment by showing a chain of title reaching all the way back in history to the original creditor. More often than not, for old debts, it is impossible for the collector to show this. Two high school kids spend their day pissing each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely in solidity across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking in they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. At best, their witnesses wildly exaggerating to the point of perjury. Their credibility was shaky and being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims. At trial, the plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damages of Kid B, and his potential earning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation. The restaurant was safe. So when we reconvened, defense rests, Your Honor. The plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, I take it you will need a few minutes for your close. After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury, Kid B 10% at fault. Kid A 90% at fault. Restaurant 0%. Corporate lawyer, but this was on a pro bono housing matter. My client just needed to not lose her housing. I was trying to get her on 1-year probation, but would agree to 2, instead of termination. On the day of the hearing, I had 6 summer associates come with me, each carrying huge binders. When my hearing was about to begin, I had them all bring them in and sit them in front of me. The opposing lawyer was a very overworked NYC housing attorney who had budgeted an hour that day for my hearing. She instantly goes, "What is this?" I told her it was my arguments. She said she didn't have the time. I started off on a 2-minute opening I had prepared, then grabbed one of the binders and she was like, "Let me stop you there. What do you want?" I said 3 months probation. She counted with a year, ended up agreeing on 6 months. The binders were all empty. I was a defense attorney for people being committed for involuntary psychiatric treatment. My client's main psychiatric disturbance was hyperreligiosity. It's important to understand that this case was in a very conservative jurisdiction, like salt of the earth USA style. Most of the cases I'd lose since the judges were generally pretty paternalistic. "Oh, this person is sick. The doc said so. Take the meds." So as the psych basically described the symptoms, and when I crossed I dug into the hyperreligiosity description. The psych had difficulty expressing exactly what hyperreligiosity was in his mind and kind of danced around it. I finally got him to say something like, "Well, the patient thinks he has a personal relationship with God and God speaks to him." Then after a little more back and forth I got down to what makes him different than a typical religious person. A person that believes in God but isn't experiencing hyperreligiosity, and the psych says, "Well, I think that anyone that believes in God is delusional and experiencing hyperreligiosity." Didn't play well in the sticks. Judge's mouth fell open. Petition dismissed. My client and his wife were woken up one night because people were trying to break into his house. He fired 2 warning shots as his wife called 911. The neighbor also called 911. When the police got the neighbor's call that there were shots fired, the police sergeant radioed the other officers and said he's going to jail tonight, referring to my client. So obviously, even with signs of someone trying to break in and his wife calling 911 for help, the officers arrest my client for endangering his wife by shooting inside the house, nowhere near her. It gets to a jury trial and I start to go off on the police sergeant about why she would say that before an investigation and before she even had any idea what happened. The sergeant had no idea how to respond and literally just sat there staring at me for a solid 2 minutes before saying anything. Even the bailiffs were audibly laughing. Back when I was a prosecutor, I had a defendant object that I couldn't compel him to give a fingerprint sample for comparison. It's how we proved up prior convictions. Our expert would fingerprint the defendant outside the presence of the jury and in the presence of the jury compare fingerprints to the ones included on old judgments. This is 101% BS because fingerprints are testimony and can be compelled. But the judge for the day was actually buying the argument. So I stood up, told the judge I was applying for a search warrant, and asked to be sworn in. She swore me in. I applied for a warrant, and she wrote out a warrant return for his fingerprints. No longer with a valid objection. The defendant was fingerprinted and surprise surprise his 4 prior felonies were indeed his. He's serving life now. His crime? 2 weeks after getting out of prison, he bought some coke, which he then mainlined, which he then drove on, and while driving, ran a stop sign. When an officer tried to pull him over, he fled and threw his coke and needles out the window into a residential neighborhood, where he crashed his car into a house. So when the officer got out to check on him, he tried to run the officer over. The officer shot him in the chest and then performed life-saving first aid until the paramedics could get there. My mom is a lawyer and this was a black woman who was accused of stealing. My mother is also black. I'm mixed, and this is how it went. Plaintiff lawyer, please point out the accused defendant. Officer points at my mom. Mom, I'm the lawyer. Officer, judge, dismisses case. This isn't an I rest my case moment, but it was a damn fun cross-examination. I was defending an alimony case, and in my state cohabitation with a new lover is a bar to alimony. We had had a pie on the plaintiff's tail for a few months and she and opposing counsel had no clue. I had a mountain of evidence that the plaintiff had moved in a new boyfriend and they were essentially husband and wife without the marriage certificate. So, if I could prove cohabitation, she didn't get alimony. On cross-examination, I'd set her up with a question I knew she'd lie about and then hit her with a photo contradicting her. So it's your testimony that John Doe never visited your house. Oh. So do you have an explanation for why he's walking in your front door in this photo? So he did come over, but never stayed overnight, I see. Do you have an explanation for why his car was parked outside of your overnight on X, and X nights are seen in these photographs? For a solid 45 minutes to an hour I'd ask a question, she'd lie, and then I'd impeach her with a photo directly contradicting her. I was catching her in a lie per minute or more. She never wised up, either. After the first few times you'd think she'd tell the truth knowing that I'd just catch her in another lie, but nope, she just kept on lying. Again, it wasn't the flashiest or even an I rest my case type moment, but it's the most fun I've ever had on cross. In the subsequent order the court made the specific finding that the plaintiff's testimony was without an iota of credibility. Thanks for making it to the end, you're the best. Thanks for watching friend. Don't forget to smack that like button and subscribe for more of the best content. See ya next time.